Well, we've got plenty of them.
Hey, good evening, and welcome to the 38th Public Police Oversight Board. Closed meeting to order. Need a mic? Okay. We're going to have the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. Our mission statement is advancing constitutional policing, accountability for APD and the Albuquerque community. Can I get approval of the agenda? First of all,
That we approve the agenda?
I'd like to make some changes first.
Oh,
Okay.
well, that's how it works. Motion, second, discuss.
Yeah. Motion?
Motion to approve the agenda.
Second. And discussion. We're going to remove case number 055-18 from the administratively closed cases.
Third column, next to the last one.
Okay. And then we're also going to add CPC report under the city staff.
Where does it go? At the end?
It doesn't matter. I can do it at next to city council, or doesn't matter. I'll put it in there. Let's go at the end.
Okay.
Okay. Alrighty. So, any public comments? Who do we have?
Did we vote on the agenda?
The
I think we
changes?
motioned in second.
Okay. Oh, we didn't. All in favor?
Aye.
Aye.
8, any opposed? Okay, 8 accepted. Okay, public comments, Patrick Artencio. Welcome.
Hi, my name is Patrick Atencio. Hello, my name is Patrick Atencio. I came here because I was pulled over by a Sandoval County police officer in Albuquerque city limits. And he pulled me over, so, you know, he took about 6-7 minutes and didn't do nothing. So then I pulled out my phone and showed him my cell phone, and he just drove away telling me I was number one. Yelled at me through 2. So I dialed 911 and put it on speakerphone and followed him. It took about 20 minutes before he stopped. So then it took about 3 hours to get APD to show up. And when they did, they told me that I broke the law by trying to hold a police officer accountable. It didn't make sense to me. It went to court. The APD officer never showed up over the 6 months or whatever the limit is, and then they dismissed it. I tried to get it investigated. I don't know who to turn to, so I came over here because I seen it on the news last month.
Okay,
So it happened last July,
okay.
and
So-
they never investigated. They told me I broke the law. I was driving reckless, and I wasn't driving reckless. And this Ashley Simpson lied outright on the police report. She's APD officer, and there's no way to get them. I tried for full disclosure in the court case. They never even called me or nothing.
Okay.
I filed motions. So how do you stop
Is your
this crap?
complaint with the Sandoval Police
Both.
Department
Both.
or
My-
APD?
He violated my civil rights by
Okay.
pulling me over and not letting me know why. And then the APD officer violated my civil rights by lying about me in court.
Okay.
And I've been filming the police parking illegally by the city courthouse over there on Slate and Fifth, in that area. I mean, I've had, on this phone, I have like 5 videos, and on my other phone, I had like 10 of them.
Okay.
And I'd call 242 cops, and they would never send over a cop.
Okay.
And I'd done it time and time again. And finally, I called the parking enforcement, and the guy showed up, and he went put a ticket on it, even though it says no parking from here to
30
the
seconds.
corner.
Okay.
I mean, do police have the right to park in no parking zones just because they're going to court when they got free parking at the courthouse?
Let's
Okay.
take the subjects one
Yeah,
at a
go ahead,
time.
Joy.
First of all, there's a couple of things you can do. You can file a complaint with our CPOA office, which it doesn't sound like from what you told us you've done yet.
Well,
There's-
I got some today, but I haven't.
No,
filled
no,
them out.
I'm just saying, I think Ed just gave you, Mr. Harness just gave you a copy of the complaint form. So you could fill that out if you want to and give it to Mr. Harness, and your complaint will be filed. It's also possible that your complaint is with the Sandoval County Sheriff's
Well,
Office.
it
or
happened in
Sandoval-
Albuquerque.
Okay,
So-
well, but we're here to investigate wrongdoings or alleged wrongdoings by police officers in Albuquerque.
Well,
Okay,
it
so,
happened in Albuquerque.
so that, I'm just saying, those are the 2 ways you can go, as far as that's concerned.
Okay. Are you okay with that?
Do you
What
understand?
about the APD officer that pressed charges against me even though I broke no law by trying to hold the police officer accountable for his actions?
Okay. So,
That's how
I
you
have-
take care of that one.
yeah.
I went to the thing, I got
Okay.
5, 6 of them. Yeah. Okay, so what do I do with the videos? How do I give them to you guys?
You can give them to us on a disc.
Okay,
okay.
all right, thank you.
Thank you.
That's exactly why we're here, so to listen to your complaint.
Thank you, Mr. Artensio. Thanks, Joanne. Okay. Can we get a review and approval of the minutes? Hopefully everyone's read those. Need
I
some
make a
time.
motion to approve the minutes.
Chair Waits, there's 2 sets of minutes. There's the regular PLB meeting, and then there's the special meeting, so both sets of minutes need to be approved.
Okay.
Okay, so my motion is amended to be the last regular board meeting minutes.
Can I get
Yeah,
a
I'll
second?
second.
Okay. So, it's been motion and second that we approve the last minutes, board meeting minutes. All in favor?
I'm sorry, there's just one little small correction that I think is just a timing in the flow of the minutes, and that is where you are called Chair Waits before we had elected you to be so.
Okay. Well, let's get through the motion and then we'll,
That's it,
The
that we're
comment.
at the discussion.
Yes, we are.
yeah,
Yeah.
okay,
Okay, so that's the only correction that I saw.
okay.
Does anybody else have any?
Any comments? Okay. All in favor?
Aye.
Aye. Any opposed? No opposed. Thank you.
And then we have to do the other
Thank
one,
you.
the special meeting
All right,
minutes.
so can I get a motion on the special meeting?
I move we approve the minutes from the special board meeting.
And I second.
Okay. All in
Any
favor?
discussion?
Any discussion? Let me finish.
Okay.
I think I had a comment. I don't think Johnny J. was he at that meeting?
He was at
It's
the
a special meeting,
Was,
yes. Okay. Any other discussion? All in favor?
Aye.
Aye. Any opposed? No opposed? All approved. Okay. All right. Subcommittee organization, let's go into that discussion. Excuse me. In front of you, I've created a POB committee master list, and I've discussed this with 2 or 3 people, but what I'm looking for, and we can discuss this more at the end, the chair of those subcommittees, those are the names I don't have right now, but let's kind of discuss the committees right now. As you review those, are there any changes or additions that we need to make to those?
Chair Waits. I would make the addition to at least the ad hoc committee of the Personnel Committee.
Yeah, we should have an ad hoc committee on here. He's right.
So that's an ad hoc personnel committee.
And that, Eric's the chair,
Okay.
and I'm on that committee too. And Leonard, you were too, weren't you?
Yeah. Okay, any other changes or additions to that?
I would, might be needing to step aside from the case review committee at this time. So I would ask to remove myself.
So Chelsea's removing.
And Valerie's our chair. We voted her in.
Okay. And Chelsea, you're going to stay with the policy and procedures? Okay. Any other changes or additions?
Yes, Chair Waits, I'd like to suggest that since these are new committees, that at the first meeting, that an election be held for chair for each of these committees. So the current membership selects the chair, as is stated in the policies and procedures for our board. So I think whenever a new committee is formed, as has happened with a new administration, we should then elect the chair.
Well, we don't, these aren't new committees. These are standing
they're-
committees, but the only thing that's changed is maybe we've added or taken away one or two people.
Yes, the
committees are
membership
the same.
changes, but there should be a provision for electing. It can be a re-election of a chair. There's no problem with that, but there should be a provision when a new committee cycle begins with the new administration that that committee has the right to select their own chair.
In the case of case review, we did that at our first meeting. We did that at our last meeting, so that's taken care of. In our case, anyway.
So,
The outreach committee.
and who's the chair of the
And-
outreach?
Chantel.
Chantel?
Mr. Chair,
Yes.
Joanne, I didn't vote.
Oh, I'm thinking of outreach. I'm sorry.
Okay.
I apologize. Yeah.
Thank you.
Okay. So, policy and procedure chair.
We have not done that, but I would plan at the next meeting to hold
Okay.
an election. So, I
Okay.
mean,
That's.
it
that's
may be
fine.
pro
Is
forma,
that-
but I think it's something that should be done as, just because.
Okay, if
of
you
the
haven't
cycle.
decided on a chair, that's fine. We can do that at our next
But our
meeting.
next meetings,
Okay.
would that, what you want?
No problem. That'd be perfect. Okay. Any other discussions on committees?
Mr. Chair,
Yes.
I asked that to be put on the agenda, not specifically for this particular, it just as a note, the chair can appoint members subject to the approval of the board. And so, if we're trying to move toward following our published policies and procedures, we ought to try to follow that. But my question is, for example, what is the purpose of the Policy and Procedure Committee? What is the charter from this board to the Policy and Procedures Committee? Are they to review APD policies and procedures? Are they to review our policies and procedures? Are they to review the CPOA's policies and procedures? Are they to do the long-term planning that's required? I'm on the committee and I don't know that answer. So I don't think that the board has ever issued a specific charter to any of the committees, other than perhaps the Case Review Committee, because it's specifically called out in the policies and procedures that we may have that kind of a committee. The others, I don't know what the charters are. The Personnel Committee, for example, and I'm not asking for discussion specifically from those members, but I'm just saying that it's an ad hoc committee, and so it only has very few meetings, I would imagine, And does it deal with, what does it deal with? Does it deal with, I'm sure it deals with Mr. Harness's contract, which
That's
is up.
exactly what it deals with, yeah.
I can
right now.
answer your questions. I can answer your questions, and maybe your question, the answer you seek is that, is where is it written? And I don't know the answer to that part, and if that's your request, then that's a different
Well, that
request
is
from how did
exactly,
this happen.
that's exactly my request,
Okay.
is that it does know, with all due respect, one board member's view of what is those committees are to do is not the way the board should be run.
Yeah, I agree.
And I agree with you.
Let me take this a
Sure.
little bit. And I totally agree with you. We've had these committees for the last 3-4 years, and we've never really sat down and defined a mission for each one of those committees. And I would hope that as you are appointing or you sit on these committees, that would be a task that you guys take on, is to create a mission for that group, you know, and we can put it into what we're trying to do going forward, okay? Is that too much to ask, or is
No.
that possible?
Chair Waits, I think Member Cruz has set a good example here by submitting operating procedures for the ad hoc committee. I mean, I just saw this now, and I'm impressed with the amount of detail, which seems appropriate to
Okay.
how he's going to operate. I hope maybe we can use this as something like this as a model for other committee
Okay.
procedures. So,
Okay.
so I think that, you know, an example's been set, and I think we can, you know, we
Yeah.
can each go back to our committees and try to create something like this.
Everyone agree with that, or?
Mhm. I thought, Dr. Cass, that you had done that for the Policies and Procedures Committee. You brought something to this board that talked about what you were going to do and answered the questions that Mr. Larson has. We passed it.
Well, I believe I have written several things up, and I don't know that we've ever formally presented this as something that the board, you know, has approved
Okay.
that satisfies Member Larson's request. And I think it's something that should be discussed within the committee, and then the board should approve it. But there's going to be a back and forth here. I think the board has to, I think, you know, Member Larson and I have had some discussion about this, and I think it's a question of who originates the charter. And I think there has to be, it has to start, I think it should start within the committee and then go back to the board for approval.
Sure.
And so we, you know, I think there's been some attempt to do that. I don't think it's gone through the full process of being written and approved by the board in some formal way.
Okay,
But
I agree with that, and again, let's take that on as a to-do on each board. I think using Eric's example would be a way to proceed with that as a group, as an organization, okay? Any other discussion with that, Jim? Mr. Harness?
Chair Waits, would you like to put a due date on that action item?
Well, I think for our next meeting, we can at least have a rough draft, each committee.
And that's May 16th, I think, doesn't it?
Chair
So-
Waits,
In your next meeting, be prepared to discuss that?
I took an hour and drafted something that was a purpose. That's the conceptual draft for the subcommittee of the policies and procedures, and I'd like to just pass those out and have them as part of the record. Also, I think that if we're going to form a committee, we ought to form the committee with the end in mind. What we as a board want that committee to do, not what the committee decides they want to do. And that would be under a perfect world. This is a little different because we've been in existence for quite a while. But I do believe that the board has to approve whatever the subcommittee comes up with as their purpose, and I don't know that I care so much about, I care what they're supposed to do, and they can decide how they want to do it. as long as the board doesn't have some big disagreement with it. So I'm like to pass these around and have them be as part of the minutes. Excuse me. Thank you.
All right, is there any other discussion? Eric?
Chair Waits. So there was a discussion amongst the Policy and Procedure Subcommittee about trying to set some time apart and doing a goal-setting meeting for that purpose, is trying to figure out what our purpose is. And from what Member Larson said, is that the subcommittee should not be the one dictating its own path, it should be the board. So going from that, do we need to have another breakout session, the ones that we did back when we were doing our goals for the board? Should we do that for with the whole board and set goals for the subcommittees?
I think that's a great idea. Have a special meeting, but we have to decide when, where, and how. Okay. Does everyone agree with that, or any
Chair
discussion
Waits?
on that?
May I address?
Sure, please.
Member Cruz? I think it's a great idea that the whole board gets together and we can have this discussion. And we can have a frank discussion and we can work through trying to get something written down, because that's the way we're going to make progress. We have a meeting with the board, and then we have a subcommittee meeting, and then we have another board meeting.
Right.
And so it takes us forever to get anything really done, because it just is the way the time is. So I think if we have this facilitated session, I think that's what you're proposing, Member Cruz, is that we have a facilitated meeting with the whole board, and we try to come up with some goals and purpose for the subcommittees. And so I would, if you're making a motion, I would second it.
Is that a motion?
Yes.
Okay. It's been motion and second. All in favor?
Aye.
Aye.
Aye. Okay, that's, any objections? Okay. Mr. Harness, can you take that on and set it up with your organization, please? As far as
Chair
time
Waits.
and place and things like that?
Yes.
Okay.
We'll,
Probably need a facilitator too, so,
we will, yes, we'll
Okay.
facilitate that.
okay, thank you. Okay.
I'm sorry, Director Harness, whoever facilitates that, can they be intimately familiar with the CASA and the policies and procedures so that we make sure that we're staying lockstep with that? Because I do believe that's our guiding benchmark. Thank you.
Okay. Any other discussion on that? All right, thank you. Item B, policy 3-52. Ms. Larson, are you prepared to discuss with that?
Chair Waits, I was under the impression that the city attorney would be here to present what they were going forward with, and then we would present ours.
Okay. Let's,
I guess Assistant City Attorney, Mr. Smeal, but I don't see him in the audience.
He was here, I saw him.
there he is.
And then we have.
No, that's
Mr.
not-
Aguilar
That's not
also.
him.
Mr. Aguilar.
They look alike.
Mr. Schmidt was in City.
Kind of favor?
Except he is here.
Yeah.
Madam Chair, members of the board, if you would indulge Mr. Schmiel's patience, he went upstairs to get his coat.
Oh, okay.
He'll be
So,
back.
yeah, we'll move him down, move that down on the agenda. POV legal counsel contract, can we discuss that? Or, I don't know if we even need to discuss it. Did everyone receive
Mark's letter.
Mark's letter?
Yes.
Okay. So, with that being said, let's discuss putting out a RFP, or should we discuss that at all?
Chair Waits, could you give us some specifics about when the contract expires and what the current status is?
Okay,
Can
I think
some-
Mr. Harness or Mark can do that.
Chair Waits, members of the board, first of all, thank you for a good run as your independent counsel. It's been an honor to work with you all. It's just, as I explained in the email, I think it's a good time to pass the baton. The contract should come up in June, and should be renewed on the normal schedule there if possible. But as I indicated, if there's timing issues on when you want to start someone new, either before or after that, I'll work with whatever you all want to have done. And city legal can guide you on the contracting part of it. They handle HR kind of stuff, so they can help with Director Harness on the contracting issues.
Okay. Mr. Harness?
Excuse me. Yes, Chair Waits, first off, thank you to Mark and Matt for their work and their continued support of the board and the CPOA. Their contract will expire on the 30th of June at the end of the fiscal year. And we have obviously appropriated for the full contract, so I don't anticipate that there'll be any problems with that. My understanding, but I have not gotten a confirmation yet, is that as long as the council contract for legal services is going to be less than $75,000, we do not need to do an RFP. You can simply advertise for the position and interview and make a decision on who you would like to be your new counsel.
Okay. All right. That sounds like,
Chair Waits, could you ask what the, or what is the value of the contract at this point, or the current contract?
Chair Waits, Board Member Dr. Cass, the current appropriation for legal services is $75,000.
okay, so with that being said, we're going to rely on you, Mr. Harness, to help us with that, getting the word out to the community. I think my position, what I'm thinking now, it might be that ad hoc committee that brings it to the board for a vote. Okay. Any objections with that?
Chair Waits, I think the brainstorming meeting would help with the scope of what personnel
Sure.
actions would help out, but yes, I can help out with that.
Okay. The other thing, go ahead.
I think we should just, I think we should just take our previous description, job description, because it probably already has explained the scope of what is needed very clearly, and then advertise that and just kind of like streamline it in that way, instead of brainstorming and reinventing the wheel. I think we can, if we just take our, our previous, we can all review what already exists if we'd like to do that at the upcoming meeting. But I think that that would be a better, let's start by working on what we have and then instead of starting over, because what already exists might be sufficient to find a new legal, or to, enter another contract with council.
You're living by my mantra of working smarter, not harder, so yes, I agree with you.
Okay.
Yeah, so we can ask Director Harness to just email us that. That way we can all independently review it. And if we have any issues or we think the scope needs to be expanded in any particular way, then we can place that on the next agenda.
Okay. Does the committee agree?
Yes.
Good. Thank you.
Chair Waits, I'm a little uncomfortable when we have this kind of little discussion and say, okay, Ed's going to do something. I'd like to have it as an action item on the minutes that says, this is what's going to happen, and this is who's going to do it. And that should go for anything. I mean, we were just about to say to Member Cruz, okay, you got this, yeah. And I think that we need to clarify that, because it gets very confusing down the road as to who was supposed to do what. And so I'd like to be sure that in the minutes it reflects that we've asked the executive director to send us the minutes. I know he'll do that promptly, not the minutes, the current contract, not his current contract, but the attorney's contract.
Correct.
And then we will review it, and are we giving him authority to go ahead and put out a notice?
Yes.
To associate, okay.
also see.
You're shaking your head no.
Chair Waits, Board Member Larson, my understanding was I was to get you a job description for review prior to me publishing it in the appropriate places for finding legal services. So when would you like me to submit the job description to you via email?
As soon as possible.
When can you, how long would it take you to do that?
That should be on file. That should be on record, right?
Chair Waits, I looked for it today. I did not find it, but it was a very cursory look.
Okay.
So I can go through the paper files
Is the job
and look for it
description-
as well. Look for it.
Is the job description not in the contract? Isn't the contract layout what we expect for the money?
The job description is not specific. A job description as you envision it, putting it in a journal or a paper, is not listed on the contract. The contract spells out in detail the services you are expecting from council.
Can I modify my request to send us both the contract and the job description? And I think a reasonable time frame would be 1 week. Does that seem reasonable to you? Could you get that out to us in 1 week? That way we would have 3 weeks to review it before the next meeting?
Chair Waits, Member Van de Venter, yes.
Does that satisfy everyone up here? Does that satisfy you, Jim? Mr. Larson?
As long as, I mean, our experience so far with the HR department has not been that they have been particularly adroit at responding to our needs, and this contract will be up, and they're gracious enough to say that they will stay to help us until we get it. But if we're gonna wait till the next meeting, so it'll be May, that we then approve it and publish it, and so then we need it done by the end of June, that's enough time.
Chair Waits, would you guide us through what the process is for a new contract? And so I don't know that it goes, I don't know what the process is, so I'm curious is what's the expectation? What departments have to approve this, and how does it get approved overall before the board gets it? Once the board approves it.
Chair Waits, Board Member Dr. Cass, you'll identify candidates, and then you will interview those candidates, and you'll make a selection. That selection, I would imagine be presented with a contract, probably most like the contract that's already in place. That contract would then go to HR procurement, and we, as the agency, will set aside the entire amount for the contract as is proposed. And then it gets paid on a monthly billing basis. I wouldn't anticipate the same type of delays like we've had with the ISR contract, because the ISR contract was something that was of first impression, because nobody contemplated that we would outsource data analysis, and this is already in place, and it would simply be taking one firm out and putting another firm in, and the budget already has requisitioned an amount for contract services, so it would simply be placed under that budget item.
Okay.
Director Harness, is there anything we could do to expedite the advertisement and hiring process to ensure that we won't have a gap of time between when our current contract expires and when we might anticipate having a new contract counsel?
Chair Waits, Member Van de Venter, I think you'll probably need to have a personnel meeting to do those interviews, to whittle down the candidates that you want to present to the full board, and then have the full board review the top candidates as your selection committee moves forward. You know, I don't know how many law firms are going to be looking to do this type of work, so I don't know the market, honestly.
Okay.
Is there any way that we could is there any way that we could agree, you know, if Director Harness were to send us the job description and the contract, and we were able to all independently review it, and we all concurred with what already exists, we don't feel like any additions or amendments or changes are necessary. Is there any way we could, prior to the next meeting, give Director Harness approval to post the job and advertise it appropriately without us having to meet again?
Okay.
That way we don't have such a delay in time.
Mark, how does that affect the Open Meetings Act?
You, Chair Waits, members of the board, I think you would have to give the delegation to Director Harness to confirm that the job description conforms with the needs of the agency and the board now, because otherwise you would have an out of meeting vote that would occur by email. So it would have to be, unless you'd have to delegate to him now, unless he determines that revisions need to be made subject to board approval, he can proceed, and you could do a vote along those lines. But if you do anything that requires circulation to the board and a vote after that, you'd need to be back in session.
Can we say to him, you know, we're giving you the authority to do that now unless you get 3 board members that bring back to you strong objections, at which case then we bring it back to the meeting?
I think I think you're going to have to give the authority to Director Harness to determine if there's a problem with the scope. I'm certainly happy to work with him and look at it and say, this is consistent with the work I've done and the job experience I've done, and so we can confer on that. But there's not a way to give the board another look at it short of having another meeting or waiting till the next meeting.
Can I ask a question?
Good.
I can't remember who came first. If you were hired first or if Ed was hired first. Ed was not. So he was already here when you came. Okay. And as I recall, we did review, and I believe it was the chair that reviewed with some of the other people, I think the vice chair and the chair, took a look at that on behalf of the board, because at the time, we didn't have Mr. Harness available. But I think the person who's done the job is you and Matt. And so if you look at the job description you're operating under and the contract that you're operating under, if you had any suggestions for your successor, could you give those to Mr. Harness and we would ask him to incorporate those in his search? Couldn't we, does it not follow that once we sign a contract with somebody, we could amend the contract if we wanted to later? It doesn't seem to me there's going to be a significant change, is my point. So why are we waiting? Yeah.
Chair Waits, Member Fine. My recollection is that the posting says in very broad terms to be familiar with the settlement agreement, the police oversight ordinance, and then has relevant experience in Open Meetings Act, Inspection of Public Records Act, civil rights. And so I don't believe that there was a massive change in what happened then to now, but I did come before you had the current structure with a permanent director in place, so.
Okay.
Okay, so, yes.
I'm wondering if this is sort of a general counsel position, am I correct? General counsel for the Police Oversight Board. So the scope is going to be really broad, as you just described, and the appropriation is already set. So I'm wondering if the board members might be comfortable on today's date right now giving Director Harness the approval to post the position without us. We could potentially, I'm proposing, skip the step of having us review the contract and the description if we're comfortable with the scope as it exists.
I don't think the scope or the contract is going to change.
Neither
So I agree with that if the board is comfortable with that, so.
I would agree.
So,
with
let's
Chair
do
Waits,
this.
sorry,
Yes.
I'm sorry to interrupt members of the board. I had, Matt Jackson just emailed me the job posting from when I got through, and I can read it to you all and you can decide if it seems to fit, and then that lets you get through this first step. The contracting can come later. I mean, you can always revise the contract in the negotiations,
Yes.
but you want
Please
me to
do, yeah.
read that? It says, This is from the April 22nd, 2015 New Mexico Bar Bulletin, Independent Counsel. The Albuquerque Police Oversight Board is seeking a contract independent counsel to advise and represent the POB. Must be New Mexico bar member with experience in civil rights, police misconduct cases, criminal law, contract law, municipal regulations, Open Meetings Act and Inspection of Public Records Act, and union contracts. And then the rest of it gets specific, and then it says submit letter of interest and CV by May 1st to Beth Moore, POB Personnel Subcommittee Chair, and then gives an email address.
Okay.
Thank you.
I motion that we allow Director Harness to post that position.
Second.
Okay, it's been motioned and second that we allow Director Harness to post that position. Are there any questions? All in favor?
Aye.
Any opposed? All in favor, Mr. Harness.
And Chair Waits, I do have one more thing, just to, I want to make sure this is as tidy as possible, that way we don't have to spend time in the future fixing stuff. Should we decide at this time also a closing date for the position? That way it's in advance of, I don't know, that way we know when it is and we know when the Personnel Committee could anticipate setting interviews, et cetera.
Good.
And your posting, Mark, was what date, and with a May, what date
Your
response?
leave date.
It was a very short,
I think it was 2 or 3 weeks.
yeah, this was April 22nd to May 1st, but what I don't know is if this was the first bar bulletin that appeared in front of. But I think you will have a little more flexibility than that. That's like 10 days, 10 or 12 days.
Is it our business to, maybe that's something HR does. I'm not sure if they would.
No, it's our,
It's, okay.
yeah, it's us.
Okay.
Okay.
And
I
I
don't
would
care
be
when it is, I
proposing
just
that
think we should set it.
Yeah.
a personnel committee meeting.
So your contract is up when?
June 30th.
30th? Okay.
So
Okay.
I think by the end of May, mid-May.
Yeah, mid-May.
Yeah.
How about by
I
May,
might
what's May 15th?
suggest The
Tuesday.
Friday, first week of May, that way we can get all of that pulled together and be able to discuss it.
We're gonna want candidates to have
Yeah.
time to see the advertisement though, because we're
Yeah.
already halfway through April.
Yeah.
And if memory
Almost
serves me, we
posted
posted it more than one time
It's 3
on this.
weeks.
Mhm.
3
Okay.
weeks in a day.
How about Friday, May 11th? Is that good with everyone? That gives us
Because how
4.
often does they
That's
post in the
a
bar
month.
bulletin? That comes out, what, once a month?
It's weekly.
Oh, it's weekly?
I
Okay.
feel like I would say the position should be open for a month.
That's what it, but that's the deadline.
Well, the 11th would
But
be
we have to
a day
post it
shy.
first.
Well, 2 days shy of a month.
I don't know how, I think we wanna give Ed at least, a handful of days to get the posting out there. I mean, are you gonna do this tomorrow morning?
Okay.
Okay, so
I'm saying the 11th. Does anyone object with that?
I object.
Okay. So what date are you?
I would propose May 18th as a compromise. I really would, my feeling is May 30th, but May 18th I could compromise on.
Any issues or concerns?
I just think that that's not going to, like ideally we would get this done as quickly as we can to the end of the current contract's expiration, right? I mean, ideally.
But this is, yeah, but I think the problem is that you're assuming we're gonna have attorneys chomping at the bit for this position.
If we don't, we still have another board meeting before the May 18th that we can
And we could
say,
extend it.
Like the 11th, if we closed it on the 11th, we have a board meeting on the 16th to say, hey, we don't have enough people, let's talk about bumping
Open
this
it
out
up.
some more, or look at rewriting that.
All right.
I could make a case.
I
either
make
way.
a motion that we set the date to May 11th. All in favor?
Aye.
What?
Yeah.
Second.
I got 3. Okay, all in favor?
Aye. Opposed.
Any opposed?
Nay.
2 opposed. Okay. So May 11th is the date by unanimous vote.
Not you,
Not
wasn't
unanimous.
unanimous.
I mean, vote, majority
It was
vote.
passed.
Majority vote, okay.
Chair Waits, members of the board, the last thing I'll say is really if there are hiccups in the process, we're not going to leave you in a lurch, and we'll transition with whoever takes over smoothly. So there's not going to be a bump in your services here.
You know, Mark, I kind of assumed that, and I really want you to know I appreciate everything you've done. I mean, we've walked together since day one, so I appreciate that, so, thank you.
You too.
Chair Waits, I'm posting this, and am I directing them to send the information to me, the applications?
Yes, please.
Okay. And then who would you like to designate from the board to review those applications? Or do you want all the applications to come to the full board at the next meeting?
No.
No.
I think, no.
No, I
'Cause we could
remember
get-
that they came to the Personnel
Yeah.
Committee, and we vetted them, and we
I
pulled
think,
out a few, and then the board
right now
decided
the-
who we were interviewing.
Okay.
I'm sorry.
So you're designating the
Personnel.
you're designating the personnel at the subcommittee as the
Point of
the
contact.
vetters of the applications?
Correct.
Okay.
Okay.
And can I join that committee for the purposes of reviewing?
Once you're on the committee forever. Just let
Yeah,
me know.
that'd be great. That'd be great.
That's
Okay.
really serious.
All right.
I'll have to think about it.
Thank you all for that. All right. Okay, Mr. Smeal, are you prepared?
Chair Waits and board members, good evening.
Good evening.
What, you know, really I can field questions on the policy. I can walk you through it again. What was sent on or about the 26th of March is fundamentally the same thing that was presented in different meetings. There was a subcommittee meeting where it was presented. There was a meeting in March, I think the 13th or so, where it was presented to, I think Mr. Cass was there, Dr. Cass rather was there, Mr. Larson was there, some others. I also had a discussion, I think at one of the POB meetings about the policy development flow chart, which I thought was the most pressing concern from past conversations. So really, you know, however you want to do it, I have Mr. Harness has shared something with me here for the first time. I'm not sure that I can read it. These are his questions? Oh, okay. Okay. So I think I could open up for questions, if that's how you want to approach it.
Yeah, he's asking.
Chair Waits, see, Mr. Schmiel, so is this the document that you all have now that you're going to present after you get our input? Does it have any changes that were made as a result of that meeting that we had on like March 11th? And we got a copy of something from DOJ that had some notes on it. I may be off on March 11th, but the meeting, and it had some notes in the margin as, you know, edit notes. And I don't know, did any of those get changed, or did you all just send the same document back?
So the edit notes that you're referring to, I'm sorry, Chair Waits, Board Member Larson. What, I'm not sure, so the first question, the answer to your first question is the document that was sent on the 26th of March by me, and then it was forwarded to Director Harness at some point. That was changed after the meeting on the 13th.
Okay.
And the changes that were made were geared primarily toward addressing clarity around how the process would work, like OPA, and you were there,
right.
Board Member Larson. I think that you heard a lot from community members, the amici, the Community Coalition, Dr. Dean Mathewson, about making it simpler to understand the process. So that was the thrust of changes that were made. And then the second question, I'm not tracking that because I'm not sure exactly when was that sent, the change document by DOJ?
I don't have the date that it was sent.
I believe it was around April 30th.
April?
No, sorry, March 30th.
Yeah, I'm not. So the process that we were following was to get comments back from DOJ and the monitor this week.
Okay.
And so those, along with your recommendations, will be used to create a resolution draft to be submitted to Dr. Ginger for his approval or disapproval.
Okay,
So that's
then-
that's the process that we're following.
Okay, thank you.
Sure.
Then I think you were given a document there from Director Harness. And
was.
these are my comments. The board hasn't made any decisions on these. They are tied, many of them are tied to comments that were made by the, in the notes section of the draft that I looked at by DOJ. Number 8, section number 8, it says the current language says the PPRB has the final authority to pass, table, or deny a policy proposal. I'm proposing that the board adopt the PPRB, has the final authority to pass, table, or deny an internal policy proposal. The PPRB has the authority to review and make a recommendation to the chief to pass or deny any policy proposal from the Police Oversight Board. I believe the concern was that if we make a policy recommendation directly to the chief, excuse me, it's my daughter. Sorry, I apologize. That the PPRB doesn't have the authority to deny a request that we make directly to the chief. The chief has to make that decision. And however they decide they want to do that in that process is their business, certainly. And then,
Chair
Excuse me.
Waits, Board Member Larson, we agree with that.
Okay.
That language that's been struck through is not clear enough. I don't think it makes it clear that there's more process behind that. It makes it seem almost authoritative that the PPRB can do whatever it wants.
Okay.
And that's not the case.
okay, thank you. I didn't think that was the case.
Chair Waits, I'd like to make some comments, and that is to put a different perspective on this, or more perspective on this, I guess, and that is that we've met several times. With,
Excuse me, Member Cass, I haven't finished.
Oh, I'm sorry.
I apologize. Okay, thank you. Now, maybe I should ask if the board agrees with that statement.
I think I agree with you.
And maybe what it would be good to do is to track the statements, and then at the very end, say whether we agree or not, because it's important for the department, and it's important for DOJ and Monitor to have our final input. That doesn't mean that they're gonna take all of our input, but we're gonna give it to them. And they've been giving us plenty of time, so.
Mr. Larson, why don't you just go through each one of, starting with 11,
Right.
and at the end, we'll have discussion on any additions that we have.
And I've also prepared some comments too, so maybe I could go after Jim.
Okay.
Thank you. Let's see, I added in the paragraph 11, after a possibility policy, once it is passed, the PPRB will be presented by APD at a POB meeting for review and commentary and stand for questions. 30-day review period will begin on the date APD makes the presentation to the POB, and then it continues with the rest of it. I know this is pretty controversial between us and our view and APD's view, but it is our understanding, from my information and belief, that the Monitor was pushing this and agreeing to this, that DOJ agreed, and that in fact the prior city attorney had agreed, but it never got incorporated. So that would be something that we would like to see put in there. 12 is a resolution draft considering comments by the POB from the 30-day review. That's just allowing, making sure that we
Your
get
mic
the
isn't
30-day
on.
review.
Put your mic on.
That we get the 30-day review. And I'm not going to start over, much to everybody's relief. Paragraph 13, the chief of police will have 45 days from the receipt of any policy recommendation made directly to the chief from the Police Oversight Board, and then that just clarifies that a little bit. And then paragraph 15, the OPA subject, this is our recommendation, or if we adopted it is, the OPA subject matter experts will include the POB and CPOA in the policy development process, creating a draft with revisions to the existing standard operating procedure as part of the packet presentation to OPA. The concept there is to try to get us involved as they're developing that packet, not waiting until the packet is sent out for the 2-week notice. And the whole idea is, and our intent is to try to expedite the process at the very end by us being involved in knowing everything that's going on up front. And so those are my recommendations, and I made them to the board for their consideration, but they haven't heard them tonight, and they have to hear them tonight. Thank you.
And
Go ahead.
Chair Waits, Board Member Larson, with regard to 11, I completely understand the logic in 11, and I have no recollection of that being agreed upon by the prior city attorney, anyone, and I think that Board Member Fine and everyone involved in those conversations knows there was little concurrence on things. But as it relates to what you have here, is there an ability for there to be, because the big issue is 30 days between meetings. Is there an ability for a special meeting so that that time frame isn't so prolonged? Because if it's something that falls, you know, basically you're going to have to wait that 30 days. That's an immense amount of time for the department to engage in the policy process. I mean, that's just a really big gap in time. Is there that possibility? And that's a broad question, not directed just to Board Member.
You want me to answer that?
Larson.
I was just going to say that when I was reviewing the comments provided back from the DOJ, they were in agreement that 15 days was not sufficient to be able to review that, if I'm not mistaken.
Chair Waits, Board Member Galloway, I think what they were saying was to make it clear that y'all had 30. Because what it is you get it, and then at the 15-day mark, it's provided to the monitor and the parties for their comment. At the 30-day mark, you have the comments back from everyone so that that resolution draft is prepared. And I think what they were saying was it's not clear in the language as provided in the draft.
I would have to agree with that.
That's possible, yeah. Mr. Larson.
Chair Waits, Mr. Schmiel, I even proposed that in one of our meetings as an alternative to try to have a win-win and meet people part way. And I don't know how we write it in there, but, and if somebody has a proposal to do that, I think that we should entertain, if there's a urgent reason to have this done, that we should be maybe willing to have a special meeting to just talk about, you know, that policy and get it to the department. I would hope that it wouldn't be just routinely that we would have that. You know, we should be on policies like this one that are holding things up, and we would be happy to do that. But I can't speak for the board, but I can tell you that it was my thought and the recommendation in a meeting, I think with Commander Campbell, that I and others, that we consider that. So I would think that we might consider that as far as I'm concerned, and I don't have anything else. Thank you.
John, that's fine.
I've been party to a lot of these meetings about this subject. And if I think I could almost directly quote Elizabeth Martinez from the Department of Justice by saying, from the U.S. Attorney's Office, but by saying, why is there time for everybody else in this process except the civilian review? And so I know that she was, and others in the monitor's office, were concerned about making sure there was enough time. At the time we were talking about changing this process, we were already 6 to 8 months past due on things that were supposed to have been passed. So we're talking 6 to 8 months on many of the policies, and then we're arguing over 15 more days. So I personally think that making the presentation, you know, it's an act of good faith to make sure you make time for the civilians in this community to have input, and we have a vehicle to that. And I think one of the things that's really great about Mr. Larson's point is that APD uses this venue, televised venue, to share with the community what the thought is and about this particular policy, what are best practices, what's the backup for all this. You know, I'm not saying that every policy has to go through all of that, but I think the vetting of that is smart. And to say we're holding up the parade is just flat not true. I'm sorry.
Go ahead. Chantel had, had some other, Chelsea, I'm sorry, had some other comments for you.
Don't worry, people always get Chantel and I confused.
Yeah, there you do. I do.
It's happened about 20 times so far, I think. Okay, so I just wanted to go through a few. So I'm working off the draft with comments that was mailed out at the end of March. And my first comment is that 3-52-2 Section A needs a more accurate definition of the CPOA and the POB. It's not thorough, and it needs to correctly state, I believe, the mandates of the CPOA and the POB that come from the binding authority, which would be the CASA and the ordinance. And so I have it here. Gosh, let me make sure nothing happened in my draft. Those would be from paragraph 271 of the CASA, I think you could take them, which states that we investigate citizen complaints. Additionally, serious use of force cases. Additionally, officer-involved shooting cases, that we review and recommend changes to policy, and lastly, that we monitor long-term trends. And so I would ask that to be edited. Section 3-52-2B, I agree with the comments made by Mr. Killebrew about explaining the OPA, identifying them. I agree with the comments made throughout about replacing the words community and stakeholders just with public throughout this SOP to make it more clear that we're not, we don't need synonyms in this SOP. I think it's more clear without synonyms. 3-52-C, I would strike, give me 1 second, sorry. I would strike the language of upon those policies, because I don't view the police oversight board's role as being limited to only the review of these particularized policies. We can do more policy work than that. And I don't want to create areas of confusion throughout the different policies that exist on these matters and the different areas of law they come from. 3-52-3A, sections 1 through 7, I think there needs to be greater clarity, especially on the chronology. Just reading through, I didn't feel like it was as clear as it could have been. On section 8, I agreed with Jim's edit, or sorry, board member Larson's edit. On paragraph 10, I felt like paragraph 10 was not clear somehow, but I can't recall exactly. I should have taken a better note there. I apologize. On paragraph 11, which I guess is the one that we were just having some contention around, I think that it should say will be formally presented by APD at a POB meeting. And then it should say that the 30-day review period begins on the date of formal presentation to the board. I think that the board doesn't agree on the comment I'm about to make, which also pertains to paragraph 11 or section 11. But I think that everything should go to the monitor all at once. I feel like there's something, what's the right word? Something subtle about sending it to the monitor at the 15 days after you give it to us for a 30-day review. To me, it makes it feel like the work we're doing is not especially meaningful, because you say, it almost seems like you're giving it to us as a courtesy to comply with what's required, and then you're gonna wait a few days and then you're gonna shoot it off to the monitor. And I trust that the monitor will wait for our feedback, but I think it would be more considerate to just wait to send these proposed policies to the monitor until everyone has had their chance to speak on it. We come in at the very end of the game, so I don't particularly like being cut off in that way. Regarding your question about whether or not we should have a special meeting, I find myself in between where Board Member Fine stands and where Board Member Larson stands. I feel like I personally could be amenable to a special meeting in some instances, but I would also agree with Board Member Fine that it's not a particularly fair request, given that, I mean, just this policy alone, how long has it taken for the creation of this policy? I don't think that, you know, giving us 30 days is an extraordinary length of time to feel that APD, I mean, I just don't think that we're holding I don't think 30 days from the Police Oversight Board is really considerably holding the process up such that that we should be required to have special meetings. At the same time, I think that we could be amenable in certain instances, but I don't think that it should necessarily be required every time a policy drops for us to do that, for us to kind of hustle when everyone else has had the ample time that they've needed. And then paragraph 13, I think I agree with Jim's edit, or Member Larson's edit, and paragraph 15, I also agreed with Member Larson's edit. And I just took notes, but if you wanted, and I don't know what everyone else thinks of my thoughts, but you know, if you wanted me to write them down, I could do that.
Okay. Chair Waits and Board Member Van Deventer, and I guess the whole board, are these going to be formal written policy recommendations? Because and I certainly can get your notes and I guess treat those as such, but as you just pointed out in paragraph 13, you know, I would think that these are board-based formal policy recommendations that you want to go to the chief to have a response back with the 45 days. It'd also be helpful to have so that, you know, I can look at these and incorporate them as appropriate. The other piece that I would mention, as far as what is page 5 of the draft and the comments from Mr. Killebrew, those certainly were taken into consideration. A lot of those were well-founded. I think that the written explanation of the policy development process depiction was lacking, and so some of those were changed. And then with the definitional stuff, I think that that's a very adroit observation with the CPOA, and I think that language from 271 could be rolled into there to capture it.
Can I respond to that question?
Sure.
I just wanted to say that as far as what I've just proposed is not a formal board recommendation, and we didn't have an opportunity because if you recall, you guys asked us to be prepared at this meeting to provide our feedback, at which we agreed to do. But we don't have, because we have the Open Meetings Act requirements, we don't have the ability to actually come together prior to this meeting and say, hey, these are the things we agree and disagree on. So unfortunately, we have to almost brainstorm in this particular way. So just to be clear, I'm not saying that the board endorses any of my thoughts. And so I guess you have to take them or leave them. I don't know.
Well, we can take a vote on that one. Go ahead.
Yes, I think whether these are formal, I mean, I agree that with Member Van Deventer that we aren't prepared to make formal recommendations at this time because we would need to have prepared these so that they could be considered by the board. But I think if you accept the recommendations that we're making, then we don't need to make a formal recommendation. I mean, if you can incorporate what's been suggested here into your rewrite, then that would expedite this process and avoid having to make formal recommendations. So it's almost an interactive process where we need to know what your objections will be to what we've discussed here tonight in order to go forward or not. We can go forward if some of these can, I guess I'm putting the onus back on you, that if you can accept what's being proposed here to some degree, then, you know, we don't need to propose everything to the, you know, we don't need to put everything into the form of a formal recommendation, so.
Sure, Chair Waits and Board Member Dr. Cass, I think we're basically addressing things the same way. You're saying you can't deal with the spontaneously sprung upon sort of editing exercise, and I think it's really hard for me to do the same thing, especially not having them in front of me. I think it was helpful to have Board Member Larson's right here, but I don't have the benefit of that from the last round of recommendations, so I think that's a challenge, and I understand if they're not formal policy recommendations, that's perfectly understandable, but it's difficult for me on the spot, without them even in front of me, to say yay or nay, and also how they've been incorporated as they've come in from the DOJ, because Board Member Van Deventer sort of made broad statements about 1 through 7 on page 3, which there's no way for me to handpick those out from what she said. And so if I can get your written notes, if they're legible, then that's fine. I was just recommending them be formal so that you have that feedback from the chief. But if that's not something you want to approach, then I'm happy doing it the way we're doing it. And then what I can do, when I send it out as the resolution draft to Dr. Ginger, I'll send it to everyone, and you'll be able to see it. And what I usually do is so you'll have the 326 draft that was sent out. You'll have the proposed resolution, and then you'll have a third document comparing. So you'll be able to see how basically everyone's commentary was folded into the resolution, and also how that changed into the final document.
Director Harness?
Yes, Chair Fine.
Chair
I
Waits.
think it's, I'm sorry, Chair Waits. I think it's important to put this in context that the board was gracious enough to agree to have this policy presented at this point because the city has already submitted this policy to the Department of Justice and to the monitor. And to now come say, do you want to make these formal presentations to the chief under the board's power, I think is not the purpose of why you're here presenting this policy today, because you've already not followed how your policy is supposed to go through the process. And it is an example of what's been going on for 3 years, and that's why there was this agreement to try and work it out this way, and have it presented and to work through this. So maybe the idea is then the board should propose that this policy be delayed, and they get their 30 days, and then they will give you their formal presentations in 30 days, and you can come back and get them.
Chair Waits and Board Member Fine, or actually, I guess Director Harness, just so the record's perfectly clear, what happened was there were all these meetings discussing this, and I understand the full board didn't necessarily have the benefit of those conversations. But efforts were made at the policy subcommittee level, meetings with Dr. Cass, the meeting on the 13th, I think it was, at the U.S. Attorney's Office, and even as part of that, with the parties and the monitor, to say, is it okay to approach it this way? To have all these meetings, to build across-the-table relationships and have the conversations that we've started since last year, and to go that route. So I wanted to be abundantly clear that that was not the city's approach. It was agreed upon by the parties and by the monitor that that would be acceptable. So there was no short-circuiting or backdooring or anything like that. It was, we're going to have a conversation. We're going to try to talk about this policy that's been going on for forever, right? I had the historical perspective. That's why I had been quarterbacking this. And that's why that approach was taken. So I want that to be clear. And I think it's just a question of, can I get them in writing? If you don't want to do them as formal recommendations, that is your decision. But if I could get them in writing, so when I get at my computer, I can say, here's one, okay, let's see where it fits, yay or nay, and then you'll know.
Okay. Sure. Sure.
What's not been reset is the valuing of civilian input. And I know you're going to tell me that, you know, everybody's real respectful now and all of that stuff. The 15 days, we were never okay with that. That is not news from us, okay? Every single time that we have had this conversation, and we have had it over and over again, We have said 15 days isn't enough, you're not giving civilians enough time for input, and by so doing, you are not valuing civilian input. And I have heard it 15 ways to Sunday, and I'm sick of it, okay? I'm sick that this policy is still going through this and still being dragged. Why do we have to have 400 meetings to say the same thing and to have our input ignored? You know, relative to that, no one's given me a legitimate reason to say 15 days is enough because your own request is, can't you just meet more? You know what? We're the only ones here. This isn't our job, okay? This isn't our livelihood. We're the volunteers here. I just think an accommodation for our time is appropriate in that, not only for us, but for the civilians we represent in this community. And it's not happening, and I'm aggravated by it, I have to say.
Any other comment? Jeff?
Chair Waits, I didn't have the benefit of being involved in all of this prior actions, and I can understand the frustration of the board that was involved in it. However, I'd like to see us move forward somehow. I personally don't think it's unreasonable for us to provide them recommendations in writing. I don't think they fall under the recommendations that it's an individual policy that we developed, and we're sending it to the chief for 45 days review. I think it's our comments in the policy process. I agree with it. I can appreciate the frustrations and I have similar frustrations with the contract, for example, has nothing to do with this. But I think that it's legitimate, and I would offer the board the idea, without making a motion yet, that we do. I don't think it would be Member Vandeventer's demise if she had to quickly write down those notes and send them to Dr. Harness. Dr. Harness. Who made you a doctor? I remember this somewhere.
Doctor of Jurisprudence.
And then we can submit those, and as the DOJ was telling us on that conference call, that if we don't like what comes out of this, then we can write directly to the chief. And, you know, we have that ability. So I think that we ought to agree, in fact, I'm going to make a motion that we agree that we will provide whatever we can concur with in terms of a board as our recommendations to this policy as it exists, with a strong emphasis on the 15 business days being changed. We have to add that, because I didn't put anything in mind anyway, and then we provide those to Director Harness, and he provides them in writing, and we try to move forward with this so we put it back in their court and not in our court. And I would really like to see us do that, and I guess however, rambled into a motion.
There's a motion on the floor.
I would ask that.
We're asking for a second for the motion.
We need a second for the motion.
I'll second the motion.
Okay. Are there any questions?
Well, I would like to ask that we have a little bit more discussion about this before we start making motions, since we were on the general topic of changes, and this deals with a specific change. So what I would like to do is table or delay this motion until we've had a chance to more fully discuss some of the other aspects of this, because it's not clear that it's appropriately at this time.
Okay, I'd like to carry that motion through, and we can discuss tabling it at another time. Okay.
I think that we need to be sure that we understand, excuse me, Chair Waits, I think we need to be sure and understand, to Dr. Cass's concern, is that we be sure and understand exactly what motions have been said. Mine are in writing, and we can add the formally to that. I saw Mr. Schmiel make that note, and if what Member Vandeventer was saying I was agreeing with, and if we agree with what she said, she can write it and send it to
let's make it, there's gonna be two motions then. Let's finish this motion, okay? And then we can make a motion to have your notes apply to the,
But can we make sure
That is his
everyone has an opportunity to comment? Because only Jim and I have been able to make comments, and I wouldn't want only our thoughts to, I think at the very beginning, Member Cass did have some comments also on the policy, and I feel like he's maybe been kind of cut off from
So we can do that
contributing.
during the discussion.
yeah.
So
Isn't that where we are?
that's
Yeah,
what we
we're
are
at-
doing.
We're at a
Okay.
discussion. I want to just make sure we carry this through and,
But
and
he has more to
Okay.
add to that.
Please.
So we may amend the motion.
So do I have the floor?
you have the floor.
Thank you. Well, I mean, I think, in general, I think that there was a suggestion that was made at the most recent meeting that we had with APD, and it was Commander Campbell and Jolene Luna and another member from APD, and Member Larson and Director Harness and myself. And the discussion, the suggestion was made by Director Harness that the POB be the center of the public outreach and of the proposal for policy recommendations or policy changes. And I believe that's what you've incorporated into your language in paragraph 11. So I think that deals with that. But I think that also deals with the question of timing. I think it takes some of the burden off of APD to try to put together some public hearing for this recommendation, and it puts off APD, and it puts the onus more on the POB to do some of the publicity and to incorporate public comment. So it seems to me that if that would be a compromise position, that in exchange for more time to consider the public comment that's presented when it's presented at the first POB meeting, you're getting the benefit of having this done in a public forum, already set up to do, to receive this kind of public comment. Now, I don't know if that satisfies your concern, Member Fine, about whether the public's getting sufficient input.
Well, I would assume.
But it seems to me that having the POB be more at the focus of the public input would be a better role for us, and it would allow for more public input. So those are my comments. And
I don't think that's wholly different from what he said, and I understand your logic, and I agree with it. I think that I would not want, as we had in this case, something was sent to us ahead of time, and we had a chance to review it before your presentation. Well, you didn't really make a presentation, but assuming that when a policy comes, it will be a presentation, I think we should have it in advance. It should be an attachment to our agenda, and then the public gets a chance to take a look at it. And then they want to come in and hear the presentation and ask questions, great. And to me, that's the part that's received short shrift in this process so far. And I wholly applaud what Mr. Larson is saying and what Mr. Cass is underscoring. This is a great opportunity to show the collaboration between the POB, the CPOA, and the police department for the benefit of the communication improvement, which is our ultimate goal. And so, to me, all of this makes perfect sense, and we've all said it before as well.
If I can add to or respond to this, and that is, I think that one of the changes that's been made is that there's a formal recognition by APD and by Attorney Schmiel to create a package that is something more substantive than I think what's been created in the past before policy meetings at APD. And so that package would be released earlier at the beginning of the process. That's sort of day zero. And that would be, go through their process, and it would be available to the public, but it wouldn't be available to the public in the same, truly until it got out to, until it was presented at a POB meeting. But nevertheless, it would be there, and we would give it additional publicity. But I think that, having that information in the form of a packet, which included research, you know, comparisons, measurables, you know, all the things associated with doing a policy development would be useful then to have on the table that then then gets to the POB and the public at the first POB hearing.
I understand what you're saying, but I don't agree that all the research has to be part of it too. I think that's part of the presentation. You know, the policy is the policy. It's not, each one's not going to be a book. So I don't know that we would have, that it's logical or possible even for the policy to include all of the rationale that went into that policy. The packets, maybe that's what you mean. The packets could have that, that's fine. But the idea is that it comes to us for community feedback. And we are and I agree that we are the ones that are saying to the public, come and listen to this and hear the logic and hear the work that's gone into this for the benefit of everybody. And that is a logical reason, and what you're saying doesn't seem wholly different from what Mr. Larson said, in my opinion. I don't see the difference. So I would just go with his motion. We have a motion on the floor.
So we have the motion on the floor.
Could you read the motion, please? Could we have, I'm not clear on what the motion is, what the motion says.
I didn't make notes on that.
He's got it.
Director Harness, if you could restate it, if you've taken some notes, thank you.
As Chair Waits, Board Member Dr. Cass, as I understand your motion, that you are going to provide a written recommendation codifying the verbal recommendations from Ms. Van Deventer and the written recommendations from Member Larson as a full recommendation to go to the parties that are evaluating 3-52, those parties being the DOJ and the city and the monitor.
Okay.
Bingo.
All right. So we have a motion and a second. And comments. All in favor?
Aye.
All opposed? Any opposed? All in favor? Thank you.
12 days?
Okay.
Maybe?
Do you have anything else you want to say to that subject? We appreciate you coming and taking these bullets that we're throwing out here. So.
Chair Waits, any day, no problem.
Okay.
Thank you.
I look forward to working with you more.
Absolutely. Thank you.
All right. Let's see. POB,
Exit
Council.
surveys.
The exit surveys for APD. We have those. Are they? Okay.
Are you, oh, I'm sorry.
You're-
I didn't notice. Who's going to discuss? Well, I have very little to report on exit surveys. I think,
You have the mic on?
yeah, I do.
Okay.
I think Member Galloway probably, or sorry, Vice Chair Galloway has a lot more to report on it. But basically, I think APD asked us to make a recommendation that exit surveys be conducted. We discussed it at the policy subcommittee. We kind of informally agreed to do it, but didn't take much action on it, unfortunately. I received a follow-up email from Director Harness stating that Councilor Gibson may have done some work on that in the past. And so with the subcommittee's permission, I reached out to her to discuss what City Council might be looking at to see if they were working on it. It turns out that City Council is not working on that issue. The issue that Councilor Gibson has worked on in the past but is not currently working on is different. She herself personally is supportive of exit interviews, but as it stands, City Council is not working on any such recommendation or policy or anything like that. And I know Vice Chair Galloway had shared with me some exit surveys that she had requested and received from other police departments. And I see some other stuff in here that I think has come from Director Harness. And so then I would just leave it to Vice Chair Galloway to finish the update.
I think that's pretty much where we stand with it. My understanding is that's going to go before the Policy and Procedure Subcommittee to develop and provide a recommendation to APD.
Yeah, I think we
And I
would,
think that's where we are. We're just trying to not reinvent the wheel by reaching out to the other police departments, specifically the departments that were brought up as where we lose our police officers to, or the ones that I reached out to. That would be Denver, Aurora, Phoenix, Dallas, and Bernalillo County Sheriff's Department. So those are the agencies that I contacted personally. And then I think Director Harness was able to pull some information from Minneapolis. So that at least gives us a starting point.
yeah, and I would hope that we can put something, get something done in our subcommittee on this issue at the next meeting. I'm optimistic about that.
So is it your plan that, can I say something?
Please.
Is it your plan then to go through these different models and see what you like and come to us with something that's
Yeah, we'll
an
definitely
amalgam
need
of
to
these?
review exit interviews, and we'll need to, I would also like to look at, I did some research myself on best practices surrounding exit interviews so that you know you're getting reliable information and things like that, and we'll need to, that'll all be a part of it. And if anyone has any, you know, stuff, ideas they want to send, or we could look at that too.
Okay.
And I would say for this one particular issue, if you know, need some or want some additional man-hours, I'm happy to help with that.
Oh, thank you.
Okay. Thank you. Thank you all. All right. So, going forward, consent agenda cases. Chair. Valerie.
Yes, we had our meeting on April 10th, I'm sorry, excuse me, at 1 o'clock. We reviewed the administrative closed cases, the case investigated, and also I-7515. And the changes that we need to make right now is that C-15518 was removed and rewritten. 192-17, there was a discipline recommended, and that was been attached. 263-17 was discussed at this meeting, but not on the agenda, but it will be on the next agenda. Our next meeting, we will be discussing minimally substantiated form 16217, and with this document, it could delay investigation process. Also, Board Member Fine worked very hard and gave us some ideas for the SharePoint and how we can refigurate it to assist us in our investigating these cases.
Okay.
I wanted to add what we discussed, which was that the administratively closed cases, we're going to recommend that they be approved, with the corrections that Ms. St. John offered. But there is something we need to inform you about, and that is that the monitor, and Mr. Harness is going to talk more about this, but the monitor has encouraged the CPOA staff to expand the definition of administratively closed cases. So several of us, we had extended conversations about this because several of the cases we thought could be unfounded or exonerated, and because the staff had done some significant work in some cases on doing this, and to administratively close it, we had concerns about the data that we would get out of that, and even though we understand that Mr. Harness is trying to deal with a definition change or a request to expand the definition of administratively closed, and he'll talk more about that. For our purposes, the committee decided that we're not done with this issue, and we're going to go back and talk about this some more. We understand the motivation for Director Harness, but we also have some concerns about it looking like we haven't done the work we've done. And is that a fair assessment, Mr. Larson?
Yes.
Okay. So anyway, I just wanted to bring that part up.
Thank you.
So with that, you're going to make a motion about the administratively closed?
Yes, I'd like to make a motion that you accept the administrative closed cases.
And I'd like to ask one quick question.
Sure.
Ms. Board Member St. John, did you approve 089-17 in the administratively closed cases?
What was the number?
Yes, sir.
089-17.
get there, just a second. Oh, that's, yeah, that's one of three. That's the one with the woman that
Oh,
made the
with
3
the-
complaints on the same
Yes,
day.
Okay, so that letter was approved?
No, we're just doing that now. Okay, so
But
that's what this
within the
is.
case review committee?
It was approved, yeah, we had some conversation about how you could combine those 3 things together, since they were all made on the same day. It's a challenge also for the staff to do that, but yes.
Okay, thank you.
Okay.
Do you have a motion
Yeah, I made a motion.
And somebody seconded.
and second?
Mhm.
All in favor?
Aye.
I have some discussion.
Okay.
Yeah.
I think there's.
Any opposed?
Wait,
No
wait,
opposed.
wait, no, he's.
Oh,
we're
you're
not-
discussing?
we're
No,
discussing.
sorry.
Yeah, I don't, I just, this is a, I think that 146 and the 143-16 in the administratively closed cases is the same case as 055-18. I'm almost positive that it is.
Yes, and that's why they took that one off.
Well, it's not taken off of administratively.
No, we took it off.
No, we just took it off of
We
the
took it off
agenda change.
On the agenda.
Oh, okay, that's what I,
We only took
Go
that
ahead.
one off.
Chair,
Director Harness.
Chair Waits, Board Member Larson, you're correct, and actually, both of those, it's one case that has duplicate numbers, and it should have been removed from the agenda.
okay, I'm sorry I missed it. So, go ahead.
That's okay.
So I'm unclear though, does that mean that, is this case being removed, or are you just removing the one case number so there isn't a duplicate case number? Or is the intent for the case to go onto the next agenda?
It is a duplicate, and that's why it was taken off.
Chair Waits, Member Van Deventer, it is the intent that the entire case come off of the calendar for the investigator to supplement the writing of the letter.
Okay, thank you.
In, Chair Waits, I'd like to add to this, or I have a question actually, and I would ask that what, if we could learn from the rest of the board who's not on the case review committee, could learn something about the process, so we kind of know what's going on in terms of the progress of these cases, where they go from here. I mean, there's a lot of, sort of obscure information that I'm sure you spent a lot of time on at the case review committee, and I would like to know how much time is expected of other board members, especially myself, to take a second look at these, or can you just tell us where everything's good and we've reviewed this and we don't need to know anymore?
Can we put a pin in that until we actually get to the reports for the subcommittees to discuss that and follow the agenda and do
Be
the
happy to.
consent? Okay.
All righty.
It's a motion on it.
So we have a motion on the floor to accept the administratively closed cases and second and comments. All in favor?
Aye.
Any opposed? No opposed. Thank you.
Okay, next we have the cases that we investigated. Do you have any comments? This is fine. The cases that we investigated,
hear
to
you
add
that
to
way.
that?
So did you have any
The
comments?
comments of the cases that we investigated?
No, we had several things we talked about,
Yeah.
particularly as it relates to the time of the incident, the time of the complaint, the time of the finalization of the investigation on our staff part. So we had some concerns about that. You may have noticed that in your reading of this. I don't think there was anything that we disagreed with the recommendation. There was some that we felt were incomplete and sent back from us. 26317, for an example, we sent back through Director Harness, and I'm not sure if it made it to this list, but no, it didn't. So that's why it's not on here. We reviewed something that ended up being cut because we weren't satisfied with the letter and didn't feel like it was complete. So those are the things we're looking for. We're looking for the quality of our investigation, as we do for the APD investigations we look at. We're looking for questions that we have. And so those are the kinds of things. For example, one of the cases was two of the the cops were called out because 2 people were very, very intoxicated, and so they were so out of it that the EMTs were called. My question is, and what we discussed was, is there a policy that says, is there an instruction that says the cops have to do that, or it's their judgment based on the harm to themselves or harm to others, that they have to do that? We don't have a problem with the fact that they did do it in this case, but it raised the question, to your point. So there were some of those, but other than that, we just kicked out 1 letter, and otherwise we approved of all the others. Did I miss anything, Jim?
Chair Waits, I'd like to just clarify that on the 26317, it wasn't a letter that we sent back. It was erroneously listed, I believe, on the SharePoint. And it never, so we printed it and evaluated it, but it shouldn't have been there. So it wasn't something that we rejected.
Okay.
It's just something that wasn't on the agenda, so
Correct.
it'll be put on the next agenda. And I just, because we were giving everybody a pretty hard time at the meeting, and I wanted to clarify that it wasn't something that we said,
And it's not on this list
Yes.
here, right?
Okay.
not something we said.
Any other comments or questions? Did that answer your
Question?
question?
Dr. Cass? Did I answer your question?
Okay.
Okay.
All righty. All in favor?
Aye.
Aye.
There was no motion.
Yes,
There was no motion, that was just a
Oh.
comment?
That was just the administrative complaints.
Okay.
Oh, okay.
I motion that we accept the cases that were investigated.
I second.
So motion and second,
I would like to open it for discussion.
okay.
Okay.
So I have great respect for the work the CPOA is doing, but that said, I did find some of these letters to be a bit disappointing, in that stylistically, I felt like the tone was often inappropriate. I would ask, I have some specific examples, and I'm not going to drag you through too much of this because I don't want to spend inordinate amounts of time, but I would just like to make a comment, that I think subjective undertones of coming from the investigators, like defensiveness on part of the officers, or sympathies on either side, whether it be towards the complainant or towards the officers, need to just be removed. These should be as objective as possible and only recite facts that result from a review of the evidence in these investigations. I felt that, at times these letters even were somewhat antagonistic to our complainants. I have an issue with that. If I received a letter that I felt like was antagonistic as a complainant, for me it would call into question, I think, the integrity of the entire investigation. And I think the investigations are good and they don't need to be undermined by the style of the letter writing. And so the specific ones that I want to object to are going to be 245-15. At a minimum, I would ask that this language be struck. The language pertaining to the child's statement appearing to be coached. Unless that can be corroborated with specific evidence, I think it should be removed. Even if it can be corroborated, I would still argue that it's not particularly appropriate. On 027-18, give me 1 second to turn to it. I'm sorry, 1 second. I think I'm going to skip that one for now. sorry, I'm trying to be selective because, on 182-17, this is not a complaint about the style, but I would like it if the letter would inform the complainant. This one was, I think it was the only sustained finding. I think it would be useful for the complainant to know to what disciplinary effect, if any discipline was recommended or not.
And we had the same thought, and it was just omitted from, it should have been attached to the letter.
Okay.
What our discipline recommendation was, and that will not go out without it being done once it's here. So that was our observation as well.
Okay. And then I'm going to keep it down to just a final two. In 187-17, I really had a problem with the notation of the complainant's criminal history. I don't believe that belongs in this communication whatsoever. What's being done here is not an investigation of the alleged offense. It's an investigation on whether or not the officer violated an SOP or engaged in misconduct otherwise. So what this says here about the complainant's criminal history, I feel that it's inappropriate. I also felt like tonally, for example, in this letter, kind of attacking the complainant for stating she was arrested for 6 hours, when in fact it was only 4 hours and 23 minutes, I felt like that struck the wrong tone.
And I think that's direct quote of what Jim said at our meeting as well.
Okay. And then this final one is within the administratively closed cases, and pertains to the question I asked you about 089-17. It says, that the complainant left, it's directed at her, and it says, you left a long ranting and incoherent message. And I think that there's another way to say that. I think that there's some attitude there that we don't need to take. And so I'll leave my comments at that. There are, I found that in all of the letters I reviewed, there seemed to always be something along those lines. And I do think we need to keep a closer eye on that sort of thing.
Process-wise, may I say something?
Yes.
Chair? Process-wise, you just made me aware of, because we've had several of these same conversations. So perhaps when we present them here, we should say what those are. We didn't like this about this, we didn't like that. I mean, we're so focused on, we agree with the outcome, but all the stuff you're talking about with tone and is it necessary to say that? I've had times, not in this case, but in other cases, where I said, if I received this letter, my hair would go on fire. I would be so mad. You would be, shooting yourself in the foot for your own purpose. And so I think maybe the way we present the cases investigated should change so that we can bring those things up. And you're the first one perhaps ever that actually shared your thoughts with us about this. But I think it's a good observation that we should.
Okay,
Director Jim brought up many of the same points you did.
I'm sorry.
I just wanted to finish.
Yeah.
Okay.
Director Harness.
Chair Waits, Member Van de Venter, certainly I will take your words and we will look at those in a different light. But I must tell you that our investigators have been tasked by previous iterations of the board of telling a complete story and having to make up a story, not make up a story, but create a full story of the complaint because it's being viewed by the public. When I have always held the position that the letter is directed to the complainant and it should be just to the complainant regarding the complaint. But we've been tasked with creating a full story for the public. So that does mean that there has to be both sides presented within that letter. Even though the complainant knows exactly what happened and what occurred, when we're responding to the complaint, yet we also have to justify the other side to the public because this is meant to tell the entire story to the public.
And Director Harness, I think I think these letters need to be written to the complainant, and also with keeping in mind that the public may read these. I don't think that there's, I don't think it's a real consideration telling both sides. I think that all that needs, I think it's very simple to determine what the facts are and state them objectively, not giving short shrift to either side or trying to present to both sides biases or different interpretation of the events. I think you just, what I think is most appropriate is to just determine what the facts are based on, you know, in most of these cases, there's lapel footage. It can be stated what did and did not happen in a non, you know, an unbiased and not prejudiced manner.
Chair Waits, Member Van Deventer, I agree. And I support that we simply present what the allegations are, what the policies are that were reviewed in relation to those allegations, and what the findings are, and leave it at that. Make it a much cleaner, simpler process so that there isn't this opportunity to be subjective one way or the other in the investigator's attempt to present a full picture, which is what they've been told they need to do.
Chair Waits, what action can the board take to weigh in on this and make a decision about it? Is it appropriate to do this at this time without any, I mean, is this sufficiently on the agenda to be able to make a motion to create the kind of letter that we want, or you know, that we want to change this, to define this task?
No, we're not going to do that. I think what we're stating here is just recommendations to Director Harness and his group, correct?
Right. This is just feedback that I have.
But-
And I'm going to, I can't be on the case review committee because of time constraints, but I'm going to continue to review them and, you know, kind of monitor this and so that we can work on it over time. But at this time, it's not a motion, it's just feedback.
I understand, and I'm trying to decide, I mean, Director Harness expressed a view that this is was a task that was assigned, or a method of operation that was created by the board, and he's operating under that principle. He's suggesting that it would be better to do what Member Van Deventer has recommended.
Yeah, but
I'm trying to decide at what point can we make a decision about that as a board, how we want to proceed from here on.
I don't think it requires a vote. I think it's just communication between us and Director Harness's group. I don't think it requires any changes from us.
Director Harness?
Chair Waits, I disagree that it doesn't require something from the board. And I think it's a great topic for the facilitated meeting rather than here. I personally think that we are writing novels in these reports that are unnecessary, they're expensive, they're inefficient, and for example, Portland just takes a copy of the complaint, they redact it, they do an investigation, and there's a comprehensive investigative file, then they write a very simple letter to the complainant and say, this is what happened, this is our conclusion, and they publish that on a web page, and somebody can go get the investigation. And it cleans things up, but we need to tell them or let them come to us and say, this is how the introductory paragraph is going to be on these, and you know, so they're consistent. Because right now we have things in here, you know, simply untrue, you know, and things like that. And I think that if we do discuss that and get input, that would be a good place to do it. And we should do it sooner rather than later, because otherwise we just don't get any action item or result. Okay.
Director Harness, was that a board voted on recommendation to the CPOA to tell a full picture?
Chair Waits, Vice Chair Galloway. It was, I don't believe it came to the full board vote, but it was from the recommendation of the case review committee.
Alrighty. Okay, we're all good? Thank you for those comments.
So we're going to put that on the agenda for the
Are you
facilitated meeting?
recommending that we do?
Well, if I need to put a motion, I'll do it, put a motion that it gets put on the agenda for the facilitated meeting where we discuss the reporting requirements from the CPOA to the board.
Okay.
Somebody going to second?
Yeah,
I can second the motion.
Okay. So motion second that we put this on the agenda. All in favor?
Aye.
Any opposed? Okay. Any comment? Any other comment?
I'm going
Okay.
to abstain from that vote.
Me?
Just going to abstain because I'm not opposed to having that discussion and having a formal policy or whatever we do. I just don't think it's necessary.
Okay. We have one abstain. Okay. Thank you. All righty.
Okay, now we didn't have any non-concurrent,
I'm sorry, but you haven't
voted.
accepted the cases investigated as yet.
oh, okay.
No. I
Motion?
make a motion that we accept the
And a
case.
second.
I make a motion that we accept the cases.
There's
You
already
did.
been a motion.
I did already.
You seconded it.
Yes.
So,
Okay. Whatever.
I thought we voted.
I thought we voted too.
No, I interrupted with my comments,
Well,
so
you
now
can't
you need
do
to go to the.
Okay. All right. All in favor?
Aye.
Any opposed? One opposed. Thank you.
Okay, now we have non-concurrent cases. There was none. The next, we have a serious use of force, officer involved shooting case, I-175-15.
171.
7115. Director Harness, you want-
Yes, Chair Waits, fellow board members, this shooting occurred on September 30th of 2015. As to the use of force by the officer, the policy in place at the time, 2-52-4, use of deadly force. The decision to use deadly force still falls under the general requirements for all uses of force as outlined in 2-52-3 of the policy. Additionally, the reasonableness of the officer's decision will include, one, reasonable belief the subject presents an imminent threat to cause serious injury to the officer or another officer or a member of the public. Two, probable cause to believe the subject has just committed a violent felony, inflicted, threatened, infliction of serious physical injury to another, and deadly force is necessary to prevent the escape of the subject in order to protect the public or another officer. In this case, the internal affairs investigators exonerated Lieutenant P with his use of deadly force. I do not concur. I find the conduct to be not sustained where the investigation is unable to determine by a preponderance of the evidence whether the alleged misconduct occurred. On September 30th, 2015, officers were dispatched to 417 Espanola Street, Northeast, in reference to a GPS location of a stolen vehicle. Upon arrival, officers observed the stolen vehicle in a driveway. Officer G requested additional units respond to the scene. Once a perimeter was established, Officer G made contact with two individuals in the garage. Both of those individuals complied with the officer's demands and they exited the garage. Upon speaking with one of those individuals, they learned that there was a third individual inside the residence. His name was Mr. Anchando. Officer G made contact with Mr. Anchando, and Mr. Anchando immediately told Officer G he was going to kill himself if the officers came inside. At this point, Officer G did not observe Mr. Anchando with a weapon. A short time later, Mr. Anchando exits the residence, and Officer G observed the subject had a black handgun in his hand. An announcement was made over the air that the subject was armed with a handgun, and the subject was advised to drop the gun. Mr. Anchando walked towards the driveway with the gun pointed up under his chin. The subject entered a vehicle and fled the scene, all the while holding the gun to his chin. Lieutenant P decided to respond to the scene because the officers requested a perimeter and because there was a possibility the incident could lead to a barricaded subject. Lieutenant P parked his vehicle on Espanola and Grand Avenue. He exited his vehicle and walked toward the scene. While walking towards the scene, Lieutenant P observes a vehicle leave the driveway and drive towards him at a high rate of speed. Lieutenant P is walking in the street. Lieutenant P already has his service weapon drawn, and because he alleges the driver of the vehicle points a handgun in his direction, he opens fire on the vehicle. He discharged 8 rounds. The vehicle does not stop. The occupant may not have been hit, and the vehicle continues its flight from the scene. Lieutenant P did not attempt to evade the vehicle, in contrast to the intern that was his ride-along on that day. The only person observing a weapon pointed at Lieutenant P is Lieutenant P. Witness testimony states the vehicle side windows were tinted. Other officers only observed the subject with the weapon pointed towards his chin. Mr. Anchondo was apprehended October 6th of 2015 by the Bernalillo County Sheriffs after another suicidal standoff. It does not appear that APD Internal Affairs attempted to interview Mr. Anchondo regarding the September 30th incident. At the time of this incident, officers were only recovering a stolen car. The subject had not threatened officers with the weapon. The subject was not the known suspect for the stolen auto, nor was he known to be a fleeing felon and a danger to the public. He only presented as a suicidal person. Therefore, I cannot concur with the IA findings in this case and exonerate the lieutenant. However, the investigation does not provide enough detail on which I can sustain the lieutenant either. Review of the investigative file of Internal Affairs and any opinion expressed in this letter are pursuant to the duties of the CPOA as described in the POB ordinance and are not intended for any other purpose. And I stand for questions.
Okay. Any questions? Ms. Fine.
One of they did find sustained. In fact, I'm sorry. They did find sustained that the Lieutenant P did not have his camera on, and they did sustain in that. So I just want to make sure that the record is clear as far as that's concerned.
Mr. Larson?
How did you know? Yeah, I read it, and I found that the investigation did not, I agree with everything that you said. I was a little dismayed that from everything I read, there were no instructions from the lieutenant to the intern to get out of the way. She did it on her own immediately when she saw the vehicle exit the driveway into the street and start approaching them. However, the lieutenant didn't. He stayed in the street, as you pointed out. And one of the things in the, I believe, deadly force policy at the time says deadly force on motor vehicles. When the only means of assault on an officer by motor vehicle, officers should not fire upon the vehicle but must place themselves in the most tactically safe position possible. At the time the threat of the vehicle manifested itself and became down the street, Officer or Lieutenant P didn't, the weapon hadn't been displayed at him at all, and he yet chose to stay in the street. So we're back to just his reporting that he saw the two things. And one time he said he saw the barrel, the next time he said he saw the actual weapon, canted it a little bit. And then when another officer called and said, hey, is this a long rifle or is it a handgun? The officer, or Lieutenant P, said, I don't know. So I don't recall. So I think that the non-sustained is reasonable. It's not saying that we think that he, if I'm correct, that it's not that we don't think that it happened, but we just, there's no evidence either way, preponderance of evidence. And then the department didn't seem to follow up on this use of deadly force. They quoted, it's in their report, but then, and they just asked one question about it, and the answer was, well, I was really shooting because I saw the weapon. And so I also think that maybe we ought to make a statement in this that says, talks a little bit about the department, maybe thinking a little bit about what the responsibilities are if you have an intern. When you take an intern to an active scene where there's an armed felon with a, and you don't tell her to stay in the car. You get out of the car and you start walking down toward the, talk about the kill zone and the perimeter. I think that that's something that we may want to take a look at as a policy ourselves. It was a difficult case to make a decision on, because I know that they're faced with a lot of really rapid decisions, but this one seems unresolvable in terms of assigning responsibility. Thank you.
I have a question about the letter. The findings letter was talking about defense of justifiable homicide by police officer was appropriate, but the suspect wasn't actually killed. So I don't, is that just like cover your bases kind of thing when there's an officer involved shooting?
Chair Waits, Vice Chair Galloway, that's always in the context of a use of deadly force.
Okay, I just wanted to be sure.
That's the evaluation.
Okay, and then I am really troubled by the fact that the lieutenant did not have his recording device on. He said in his statement that it's because he typically does administrative work, but I don't find that to be an excuse. And I would like to know why that particular issue wasn't followed up on. And then just to kind of, one thing that you had said in your letter, that there was nobody who said that they witnessed a weapon in the vehicle being pointed at the officer. There was one officer who said that he could see that he had pointed, couldn't tell if the gun was still under his chin, but he could tell that it was pointed at Parsons. But then he said later in his statement that he wasn't in the street and couldn't see where the gun was pointed. And so that kind of double talk I found troublesome when reading those statements. So I don't know if there's something to be done there. And then the last thing, and I know that it's probably not appropriate, but when I was watching the videos, I'm concerned about the way that one of the officers drove off, and that's going to be a thing for me, I think. The vehicle, the use of the vehicles. He was driving through a neighborhood. He says in the video that he didn't know which direction the car had gone. He was asking what the make and model was of the vehicle, but he was going lights, sirens, and a high rate of speed. And I don't think that that's probably something we should be okay with. So that's my comments.
Chair Waits, Vice Chair Galloway. The lieutenant was sustained for not recording the incident, so that would have meant that there was some discipline. I think that what this really kind of illustrates is maybe there needs to be an examination of the sanctions related to on-body recording device, because not recording a jaywalker is the same as not recording a shooting. It's a level 7. And I think that there needs to be some consideration about what scene is being recorded and what scene isn't being recorded. And right now, that's strictly a level 7. Mm-hmm. And I'm not sure that that is appropriate.
And level 7 is the least punishment, right?
Right, level 7, yes, level 7 is the least punishment. So if this lieutenant had no previous discipline on his record, then it would have been a verbal reprimand for not recording this incident, where I think we all agree he clearly had time to press the button and turn it on as he was driving to a scene that he knew already had a perimeter established. So,
well, in the interview, he said it was in the car. It wasn't even on him.
Yeah, he wasn't even wearing it.
Yeah.
Correct. Regarding the driving,
and it was a different officer altogether.
Right.
Was one who was involved with the case.
I understand your level of tolerance is different than my level of tolerance, but if you have someone that you believe, as an officer, has pointed a weapon at another officer, and that officer has felt the need to discharge the weapon, then you're going to move out at a high rate of speed, and you're going to be asking for that information so that you can try and join the pursuit, because there was a short pursuit in this
Yes.
instance.
And I think I
And-
would be okay with that if he hadn't been several blocks away before he started asking about vehicle, and like it wasn't an immediate, I'm going to find this guy and so I need to know what I'm looking for. There was time. There was several turns that were made and in a neighborhood where there are children, you know, potentially running around. That's my concern.
And I would just offer to you that there, is that a code 3? Is there a code 1? Which is the one that's the lights and sirens? Is it 3?
It's a code 3,
Yeah.
responding to a priority 1.
Okay, so that's the place in the policy? That's where you would look for that, is what are the rules? Because that's what you want to know. So if that's an issue for you, you may want to take a look at that.
Okay.
I have one last comment, Chair Waits, if I could. The interesting thing is we have another case where a lieutenant was involved in, intricately involved, and prompted other officers to fire extensively, and this particular lieutenant did not have their recorder on either. And so when you have supervisors that are, you know, area commanders that are involved in shooting incidents that don't wear their cameras, it doesn't bode well for a leadership principle that you will wear your cameras. And so maybe we need to kind of track that a little bit.
Chair Waits, Board Member Larson, I agree certainly with the sentiment, not sediment. But I think it's valuable to realize that this case is 2 years old, and the case that you're referencing is 2 years old as well. And we certainly can be cognizant of that, and it is certainly something that the Force Review Board is cognizant of, having been at those and having those debates, and Attorney Schmiel and I asking those questions about at what point are you going to be having some accountability here? So I think it's better. I think what you're seeing is the maturation of the process for officers with the cameras. And I think now, even with the new systems, it should not be an issue at all. But from a systemic standpoint, I'm not saying from an operator standpoint.
I had forgotten that it was 2 years ago, 2 years old on the second one. So I appreciate your comments, and I agree. I'm glad you made them.
Okay. Any other comment? We get a motion on, you want to speak into your mic?
I make a motion that we accept I-171-15.
Second.
All in favor?
I'm sorry, what are we accepting?
We're
Because Director
accepting because
Hargis,
he's going to write a letter,
This is a letter.
his
Okay,
feedback.
thank you.
And so he just gave us his feedback, we're approving, we agree with him,
okay,
and he's going to send a letter to that effect.
okay.
Okay.
Could I clarify, is
Please.
there anything you want added to this draft letter to the chief? Besides Member Larson's concerns about the investigation not addressing the shooting at the moving vehicle?
Well, didn't you tell us that the policy at the time did not include shooting at a vehicle was not a wrongful
There
deal? They were not allowed to do
Chair
it.
Waits, Board Member Fine, there was, in fact. And Member Larson, that's what Member Larson read from.
Oh, okay. My bad.
Okay.
Okay.
Any other comment? All in favor?
Aye.
Any opposed? No opposed. At this point, I need to ask, do we need to take a 10-minute break? Or do we want to continue? How do you guys feel?
Let's take a 10-minute, I make a motion that we take about a 10-minute break.
Okay. All right, let's take, let's reconvene at 7:30 if you will. Take a 10-minute break. Can I get a motion on that?
She motioned, I second it.
In favor?
Aye.
It's a 10-minute break.
Anybody want a cookie?